Hello, Attorney Kip from Malek and Malek. Today I'm going to talk about a revised code 412390, which is the workers' comp retaliation statute. And this is a really complicated, it's not necessarily complicated, but I'm always given these like admonitions or warnings like, hey, you need to get this workers' comp stuff's complicated, you need to get an attorney. You definitely need to get an attorney when you're dealing with this stuff. If you do this stuff on your own, you're risking disaster. So if you want to get our law firm involved or look at it, we can. The fact of the matter is, this retaliation stuff, you're kind of outside of the realm of workers' comp and the realm of employment law. And so we might, if you come to us, we might actually refer you to an employment law attorney, because it's not necessarily our area of expertise, but I'm going to talk about it because it comes up. So you know what I'm saying. If you need to get an attorney, get an attorney. And bottom line is, you should talk to an attorney regardless. So this is a workers' comp retaliation statute, and basically what it says: an employer cannot take any punitive action against an employee. So they can't discharge you, they can't demote you, they can't reassign you on the basis of you filed a workers' comp claim, or you're pursuing a workers' comp claim, or you have a workers' comp claim. If they do, and they're found to have violated the statute, then the relief is, if you're discharged, i.e. you're terminated or let go, then reinstatement with back pay. Although I'd ask, do you want to go back to the employer? Whatever. But and then the other thing is demotion and reassignment, and then in that case would be wages lost. So if you got moved to a different position and you made less money, then you would be reimbursed the money you lost. So there's two things that you need to do with this statute. One, you have to give notice of the violation within 90 days to the employer that you're going to file this complaint. So as soon as you know about it, again, once it happens, that's day zero. You have 90 days from day zero. Okay, and then the complaint must be filed within 180 days of that violation. So once the violation happens, you have 90 days from the date of that violation to give notice, and then you have 180 days within the violation to file your complaint into court. Okay, so as it is with workers' comp, it's always with most things, it's good to look at how the Supreme Court and how the appeals court have treated this issue. It defines kind of it cabins in the parameters of the law, and I could talk about how to think about cases, and I'll talk about that after I talk about like precedent. And I mentioned precedent, and I'll talk about in a way that might make sense to you. But first, we'll talk about this 412390 thing. So the first case is this Onderco Sierra Lobo, and there's a lot of stuff in this case, but the takeaway from this case is the elevator pitch of this case, or the short summary of this case, is this dude filed a workers' comp claim for his knee. There's a lot of mud and issues with the facts of the thing, but the bottom line is, he goes to the DHO. The DHO denies his claim, and then this guy's like, I'm sick of the workers' comp, and to be honest with you, I don't entirely blame him for being sick of workers' comp. He just wants to move on. So he doesn't file an actual appeal of the denied DHO order. So there's no SHO hearing, and then he has no opportunity to go file his denied claim to the Court of Common Pleas. So he has completely denied workers' comp claim. The employer, about a month or so later, they say, hey, we're terminating you on the basis that you filed this fake workers' comp claim, or something of that nature. So they file it. He files this 412390 action. The employer says, hey, he has no right to do that because he has no workers' comp claim. And the takeaway from this thing is, the Supreme Court basically says you don't have to have an allowed workers' comp claim in order to file a 412390 action. It's not the retaliatory discharge 412390 lawsuit. Plaintiff is not required to prove the injury occurred on the job. Proof of a work-related injury is not a prima facie element of retaliatory discharge, and the reason is because requiring an employee to prove an injury at work would have a chilling effect on the exercise of the employee's rights. And the only relevant question for trial court is whether a claim was pursued and whether the employee was fired or punished for doing so. Okay, so that's that. And FYI, and this is a video for another day, but by the way, you're not allowed to file false claims or make misleading statements in order to secure a workers' comp claim. That's a crime, and that's a crime pursuant to Revised Code 291348, and that's like another video that we should probably go into, but another video. So that's the Underco case, okay? You don't have to have a loud workers' comp claim to file 412390. Second case, Lawrence versus the City of Youngstown, Supreme Court case 2012, and this is Ohio Supreme Court. The whole significance of this case, without going into the details, is the question that the court answers is, when does the clock start for the purposes of 2390 notice requirement, the 90 days thing? So for discharge of the employee in this, and that's what they're talking about in this case, the date the employer issued notice of the termination is when the clock starts, not the date the employee received notice or the date the employee discovered that they should file 412390 action. So if you get terminated and you don't even know 412390 exists, and you're talking to your attorney and it's 91 days after you got terminated and you bring it up to your attorney, it's a day late. I always, when it's these date things, I would not wait till the 90th day. I would wait to file at the very least 80th or 89th day, but in that case it's too late. So the point is, you got to be aware of what's going on with your employee situation, and you got to let your attorney know what's going on. We're not omniscient, we're not telepathic, we don't know everything that's going on with your life, even though you may think we do, and we may know a lot of things, but we don't know everything. So you got to let us know. That's the significant thing. You got to, hey, this is what happened. You got to let them know. So the next case is a 10th District Appeals Court case, and this is a case, it's helpful for you because it defines how 412390 might play out. So in this case, it's Thievenin versus White Castle Management, and it happened in 2018. This guy worked as a watchman, and at I guess a White Castle corporate building, maybe. I assume he's not a watchman at a White Castle. He's watching the sliders cook, and he didn't do a good job. But no, that's not the case. I assume it's a building. Okay, so there's a lot of facts in these things, and there's a lot of facts in this thing. You realize that this guy had beef with the employer, and he had some grievances before he ends up getting injured, but he had some grievances, and it kind of arose because I think he was put on some weird schedule. Like, he might have worked during the day and they switched to the night, and he wasn't happy about that, and there's a lot of back and forth between him and the employer. So it wasn't great, the employment situation beforehand. And so anyways, he ends up getting hurt. He ends up screwing up his knee. He gets a claim allowed for like a meniscal tear or something. I think he had surgery, goes back to work. And then so while he's going back to work, again, there's more back and forth. You know, hey, you guys aren't doing this. It's not fair. I got to work on the weekend. Why are you making the veterans work on the weekend? That's the reason why we work here for so long, is so we earn the right to work during the week, and so we could have weekends off. And there's a lot of this back and forth. And then there's also, you guys aren't accommodating my restrictions. Well, eventually, what ended up happening is, there, in the course of one of these discussions, he was scheduled to work on some particular weekend, and then he brought up also that the employer wasn't adhering to his restrictions. So the employer was like, okay, dude, we're gonna have to talk about this, and so you're not gonna work that weekend. Don't come in, and hey, don't come in to work that weekend, and we're gonna send you, because so you understand that it's 100% clear to you, don't come in. We're going to send you this letter that says as much in a certified letter. So he got this in a certified letter, don't come in this weekend. Whether he opened the letter and read it, that's another issue, but he received it. So he comes in that week and he tells the guy, he sends a replacement night watchman home. He's like, go home, I've got it. And then the other thing is, he's got knee issues, and so his restrictions are like, you can't do X number of, you can't walk these rounds. And so the employer had seen the work restrictions that they had, and they said, okay, do this instead of that. But he ended up doing that, the regular duty of the regular rounds, above and beyond his work restrictions. He basically did his normal job. And then the following day, or a couple days later, the employer's like, hey dude, you came in and and we told you not to, and you had admitted that you worked above your work restrictions, and for that reason we're terminating you. So what this guy did is I assume he was represented, so he sends it to his employer or his attorney. They file 412390, they give notice, and then they file a complaint. And then the court, the trial court granted summary judgment in favor of the employer. And if you don't know what summary judgment is, just understand this. He didn't go to a full jury trial. They filed a motion. The court said, employer, you won without having to have the actual trial. That's what it means. So he filed an appeal of that to the 10th district, and so they kind of talk about the law in this case. So the first thing is there's 412390. So what does the plaintiff have to do? The plaintiff is required to prove only that employer took punitive action against the plaintiff in retaliation for the plaintiff filing a workers' comp claim. So they go through the three things that the plaintiff must show. Plaintiff is the employee. So engage in protected activity. What's the protected activity? In this case, he filed a workers' comp claim. He had a workers' comp claim, okay? So he fulfilled that. Subject to adverse employment action. He was terminated. He fulfills that. And then the third thing, there's a causal link between the protected activity and the adverse action, okay? He filed a workers' comp claim. He was working with restrictions, etc., and then he was terminated. So there's enough. So he's got the 4123. He's in the door, okay? So he's done his thing. So then the court basically passed the burden. It's like a basketball. You give it to the employer. You're like, here, the burden is yours. So the burden for you, the employer, the defendant, I guess in this case, is you have to give a legitimate and non-discriminatory reason for that action. So their legitimate and non-discriminatory reason for terminating him is because he was insubordinate, right? He came into work when he wasn't supposed to, and he exceeded his work restrictions. So what would be a discriminatory reason? We terminated you because you're race, or we terminated you because you're old, or we terminated you because you're gender, or we terminated you because one of these protected classes, okay? So they didn't do that. So the burden then switch back to the employee, the plaintiff. If defendant gives a non-discriminatory reason, which they have in this case, the plaintiff must show that the articulated reason was only a pretext for the adverse action. So even though the employer says, hey, this is my non-discriminatory reason, maybe that's a pretext, maybe that's BS, okay? So to prove that it was a pretext, and pretext means it's just BS, and we're just saying their stated reason is just a pretext, and they're just wanting to get rid of them. Plaintiff must prove the stated reason was one of the following: had no basis in fact, okay? So, or did not actually motivate the adverse employment action, or insufficient to motivate the adverse employment action. So, had no basis in fact. I guess if they're saying that you were terminating you because you came into work and you in fact did not come into work, there's no basis in fact. So that would be a pretext. The second one, did not actually motivate the adverse employment action. Maybe a simple example would be you work as a cashier in like a gas station, and you're chewing gum, and you have a workers' comp claim, and they terminate you, and their reason is because you're chewing gum, because at this gas station, you know, chewing gum is not a polite thing to do, and we're terminating you. That's silly. That's a pretext, okay? So it did not actually motivate them, because there's probably everybody's chewing gum. Or it's insufficient to motivate the adverse employment action. So if there's any way that this guy could have gone forward, I might say that this would be the employee's weakest position in this thing. And the reason why is, one, usually you terminate people for not showing up to work, and this guy actually showed up to work, even though he showed up when he wasn't supposed to. But one, he showed up to work, and then the other thing, he actually exceeded his work restrictions. So he's working without his work restrictions. So he was doing his job. You usually would think, why would that be a terminable offense? The court said he was insubordinate, or the employer said, and the court was like, yeah, he's insubordinate. And that's just the way the court landed. And I guess you'd have to look at the whole context of the whole thing. But I guess he was insubordinate because he was told not to come in. Okay. So, and then the court says the reasonableness of the employer's decision is critical in determining whether this preferred reason was the employer's actual motivation. I'd say it was reasonable in this case, and I think it was significant because this guy had a long history of back and forth of basically griping about this thing and that thing, and the employer trying to work with him and not, and so he kind of worked himself. And this, in fact of the matter is, he kind of talked himself out of a job. He basically set it up so he gave the employer a reason to boot him. But in the court, they said there was no pretext. The employer had a clear work restriction, or employee had clear work restrictions. Employee admitted he violated those work restrictions, and the employer's scheduled grounds clearly accommodated employees' restrictions, and they had no reason to there was no reason for him to violate the work restrictions. And then he was given a work order not to report to work, and he reported to work. So that's kind of that. So that's kind of that explores the 412390, the parts and pieces. So another case, and this is going to be the final case I'm going to talk about, and there's a bunch of cases, we go on for hours and hours, but there's another case, 10th District case, Cordial versus ODRC. This person was a security guard. They sustained an injury on June of 29th of 2003, and they didn't return to work until the spring of 2004. And then, so I think they have like a union at that job, and so the employer basically placed the employee on an involuntary disability separation, and they said if unable to perform the essential job duties, then an involuntary disability separation order will be issued. And they issued the order. The person was terminated. So, as an aside, the court basically said an IDS was not a discharge under 412390 because that employer has up to 3 years to notify the employer of reinstatement. They can get their job back. So, but the court says even if IDS was deemed to be a discharge pursuant to 412390, the employee would still have to find that IDS was the employee discharge order, or injury discharge separation order, was imposed by the employer because the employee had filed pursued the workers' comp claim. And the court further said that an injury disability separation could violate 412390 if employer used it to retaliate against the employee for asserting his or her rights. But they said that's not the case. The employee couldn't do the essential job duties. They couldn't do the job duties of a security guard. We don't have a job for you. Okay, so there's no pretext. Okay, and they refer back to this Coolidge case, and in that case, it's a similar thing. A teacher had exhausted her available leave and was unable to return to work because of her allowed condition, and the court in that case said there was no retaliation by the school board in terminating that person pursuant to 412390. So the bottom line is, if you can't go back to work and do the essential job functions, your job is going to be eliminated, and you're going to have to find another job. And there might be other things you could do pursuant to the workers' comp system, like vocational rehabilitation, these sorts of things, permanent total disability. But the filing a workers' comp claim itself is not going to it's not a guard to keep your job. You're not going to keep your job. You're not going to be able to say I have a workers' comp claim and you have to maintain my job, because if that was the case, then all the employers would have to keep all these injured people on their rolls, and the state of Ohio has determined that's not what they want to do. That would put too much of a burden on employers, and so they say if they can't do the essential functions of the job, you don't have to keep on employing them. And is it fair or not? I don't know. If you think it's unfair, then you got to tell your congressman, hey, we want to change the revised code to protect this. But that's the 412390 statute. Now, there are some things to protect your position for limited time, and I've talked about this, or I'm going to talk about this in another video about what options may be, and the basic one would be Family Medical Leave Act leave. So, but that's another video for another day. But bottom line is, workers' comp is not going to cover your position forever, and if you can't get back to work, then your employer doesn't have to continue employing you. Okay, but they can't terminate you, or they can't take an adverse employment action like because you filed a workers' comp claim. Okay. Bottom line is, this stuff's complicated. You need to call a workers' comp attorney and talk to them about your issue. Don't do this on your own. It's too many little things that could go wrong. Okay. So this has been attorney Kip Malek from Malek and Malek. Thanks for watching this vid.